Hi, I'm Jonathon Kappy.
And I'm Nick Esterbauer.
Welcome to Holland Estates. You're listening to episode number 582. Today we will be discussing the recent Court of Appeal decision of Rubner and Bistricer. This is an interesting decision. It's an appeal related to the issue of gifting, at least at first instance, and then in the Court of Appeal it morphed into an issue of trust and whether or not a bare trust had been created and was in existence. So let's first talk about what the facts are, and then we can get into some of the issues that the court canvassed.
So there was an investment by this family that ended up going into litigation later on. So the mother and father had 3 children. One was a daughter and 2 sons. And at some point in time, they invested in 10% of this joint venture that was dealing with the development of a good chunk of land, I'm assuming, in Oakville. And the issue became who's entitled to the proceeds from this investment.
Right.
So you've got 3 kids. One actually disclaimed their interest. Another one sold their interest. And this decision looked at who has maintained an interest in what was found to be a trust.
So I think there was originally a trust. So I think what happened was that, and there's a lot of facts, and I encourage everyone to go read it because it's an interesting decision. But originally, the mother held this 10% interest in trust on behalf of all 3 kids, and I don't think that was disputed. At a certain point in time, one of the sons asked for his third of that 10% in specie, which he eventually sold back to the other group of investors that held the balance of the development. And then the mom continued to hold a third each for each of the other 2 children. The daughter, whose name was Brenda, lived in the U.S., and for tax reasons, and those reasons were not explained in the context of the decision, she chose to disclaim her interest in this investment. And so by tax law, that gift resulted back to the mother, who then held proper beneficial and legal ownership of that 1/3 of the investment for herself again. And then there was the last son who was entitled to the last of those thirds. And so, there was no issue with respect to the son who took his third. There was no issue with respect to the other son who eventually got his third. So the issue related to this 1/3 that was originally held for the benefit of the daughter who disclaimed her interest, and then what happened subsequent to that disclaimer with respect to that interest. And so once that it was disclaimed and it reverted back legally and beneficially to the mother, the daughter continued to help with maintaining the cash calls, but the mother nonetheless was paying the taxes on distributions. And these 2 accounts were set up, one Canadian account and one U.S. account, presumably because the son lived in Canada and the daughter lived in the U.S. And when distributions were made from the joint venture into these and placed into these accounts, checks were written to the daughter from the U.S. account.
Right. And something I found interesting about those checks was the fact that they were, I believe, signed by the mother at a time when she was capable of signing checks, but they weren't written out and they were not delivered, and the checks themselves weren't cashed until a later point, at which time she was incapable of managing property and signing these checks herself.
And I think they were actually blank checks originally when she signed them. So at the lower court level, the argument was advanced that the monies held in these bank accounts were gifted by mom to the daughter. And in fact, it becomes part of the narrative, but not necessarily part of the decision, which was the mother eventually changed her will and added a provision in her will that the interest she held, that 1/3 interest at her death, was going to go to the daughter. So as part of the narrative, she always intended this 1/3 to go to the daughter by way of gift of some sort, even though the daughter had disclaimed the interest in the investment. And we don't know what the tax advice was, so it's hard to know whether that made a difference or not from a tax reason. But so there were a couple different ways that this daughter got money. Certainly the daughter got money when distributions were made from the joint venture to the shareholders or the interest holders, and the mother wrote checks or blank checks that eventually got filled in that went to the daughter. And so those were argued were gifts. And then the daughter also advanced that monies that sat in the bank account, which had not yet been advanced to the daughter, were gifts of future income which were promised to her. And that is really where the crux of the litigation lies.
So the lower court looked at those gifts or purported gifts and whether or not they could be effective gifts, notwithstanding that although the intention did appear to be in place at the time at which the blank checks were provided to the recipients, whether or not delivery had been effected at that time. And the lower court and the Court of Appeal agreed that no, these were not effective gifts. Delivery had not taken place, and in the case of checks like these, they need to be cashed in order for delivery to be completed.
Yes, so I mean that is what there obviously has to be intention to gift, there has to be delivery. There are a number of cases that talk about checks, even checks that were written and that were given to the recipient, but the drafter of the check dies before they're cashed. It's not valid delivery because you have to ensure that there's enough money in the bank account for the check to be honored. A check is not cash. It is not the gift itself. It is just the promise that the check will be honored and you will get your money. And so that's why courts have not regarded uncashed checks as completed gifts. So what the court went on to say is that because delivery of a gift is required, that a promise to give a gift in the future is not an effective gift, and it's not binding. And that's why checks that are uncashed are not valid completed gifts. And that's why the money that remained in the bank account, which had not yet been conveyed to the daughter, the court held, was not also a completed gift. Because it was a future entitlement that hadn't yet been gifted, hadn't yet been conveyed, and it couldn't be a valid gift.
So the court then considered the argument that the mother held the funds in these two bank accounts in trust for the beneficiaries of the initial trust.
So, but let's just clarify something first. All right, so that was what happened at the lower court. The court held that that the checks that were written by mom while she was capable were valid gifts. Any checks that were cashed after she was incapable, because mom is still alive, right? So any checks that were cashed after she became incapable were not fully completed gifts. And certainly the money that were in the bank accounts that were not subject to any checks were not valid gifts. And that's where the application ended. So then the daughter appealed and said, hold on, but there's a new issue that needs to be considered, which is whether or not there is an issue of a trust relationship between mom and daughter with respect to this money. And it's something that Justice Myers, who was the original application judge, had raised in the context of the application. It wasn't raised by the parties, but he had suggested, is there some sort of trust relationship? And I guess they didn't deal with it appropriately because it wasn't the basis for his decision, but they appealed on the basis that there was a trust relationship. So why don't we talk about what that trust relationship was supposed to include?
Sure. So the Court of Appeal provides a great review of the three certainties and the other requirements for creating a valid trust. And I particularly liked how they went into the certainty of intention, the certainty of subject matter, and the certainty of objects, and inferred really much of the intention from the conduct of the parties rather than any language pertaining to a trust or trust obligation, anything in writing documenting this trust. It just really looked at the conduct of what had happened with these gifts or distributions from a trust, and from that was able to form this trust.
Yeah, I think that the court really goes about and starts with, listen, there's no formality to create. There's no real formality with respect to creating a trust. Yes, there are formalities, and there are, in terms of the relevant parties must have capacity. There must be certainty of intention, certainty of subject matter, certainty of objects, and the trustees must hold legal title to the trust. But in this particular case, where the settlor of the trust and the trustee, who is mom, whereas one and the same person, there was much less formality that was required, because all she had to do was to declare to herself that I am now holding this in trust for my daughter, and all of those certainties would have been met, and all formalities would have been complied with, because she, as the trustee, held legal title. And the court goes on to say, even because we don't deal with real property in this particular case, there's no statute of frauds that we need to deal with in terms of having anything reduced to writing. So the utterance of I am now holding this in trust for my daughter was sufficient, with all the certainties having been met, to create a formal trust.
I found it interesting that the court went so far as to say that the only way that this relationship could be characterized was as a trust relationship with a trustee who has obligations to benefit both the daughter and the son.
Yeah, reading the decision and the facts, at all times it looked as though mom was really holding this money for the daughter, but the daughter was always benefiting it. And the court goes on to say, listen, not every piece of evidence is consistent with that, but there was so much informality with respect to how the family operated, how the family dealt with their assets, that having one or two pieces that don't align with that theory is not evidence that that wasn't the intention. Like in particular, that mom paid the tax on the distributions. Obviously that is not consistent with mom holding it as a bare trustee for the daughter, but there were other things that supported it. And so just to clarify, a bare trustee is a trust where the trustee holds title but has no active responsibilities as trustee other than to convey the trust property to the beneficiary upon demand. That's the essence of what a bare trust is. And really, this, in the context of this bare trust, the mother held the bank account in trust for the daughter until the daughter asked for it. And that was the essence of the bare trust. So, so listen, it is interesting insofar as, they went through a whole legal argument at the lower court, a decision was made, and then they appealed on the basis of a new legal theory. It didn't require any additional evidence. All the facts were before the court. And then they went to Court of Appeal and said, hold on, I've got another idea that seems consistent with what the evidence is. Will you consider this in the context of, bringing about the proper result in the circumstances? And listen, there were technical arguments made with respect to, can you advance a new theory on an appeal that wasn't advanced originally? Given that Justice Myers himself had raised the issue of a trust at the lower court, it was considered. So it was hard to say it was never considered. But I think the court rightly said, listen, at the end of the day, the issue that was put before us was, who was the owner of this money? And in the context of resolving the dispute as to who the owner of the money is, there's no reason that we shouldn't consider whether or not their trust relationship was created.
And the court also looked at whether or not either of the parties would suffer any prejudice from the appellant raising this new argument at this stage. They found that there would not be any prejudice. As you mentioned, Jonathan, the trial judge was alive to this issue, this trust issue, and they found that it was an appropriate case for a new basis of appeal to be raised, even though there is a general rule against that.
Right. So, but yeah, no, an interesting decision for several reasons. Even to be aware when you're looking at facts as a lawyer in terms of looking at a gift, but if I can't satisfy the requirements for a gift, is there something else that may exist that may help me to bring about what was truly intended in the circumstances? And so I like the fact that the court got it right. This was truly what was intended, and it brought about the correct result in the circumstances. It just needed to look at it from a different legal lens, which I enjoyed. So, but I think that concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Nick Esterbauer.
Should you have any questions, please email us at webmaster@hollandhull.com or leave us a comment on our blog.